Right, good evening, and thank you very much for joining the Bar Council's Criminal Legal Aid Billing Seminar. My name's Adrian Vincent. I'm the Bar Council's Head of Policy for Legal Practice and Remuneration. And one part of my job is to be the executive of the Bar Council's Remuneration Committee. And so anything to do with barristers and legal aid fees comes under my area. I'm going to be the sort of compere for today's seminar. We have 5 speakers who will be speaking. Our first speaker will be Tom Little QC, who is going to be speaking on CPS fees. Tom is the Criminal Vice Chair of the Remuneration Committee. He practices from 9 Gough Chambers, is Senior Treasury Counsel at the Central Criminal Court. Chambers and Partners quotes him as, quotes, juries like him. And I'm sure I can say without fear of contradiction that we like him too. Our second speaker will be Neil Jackson, who will be speaking on tips from the solicitor perspective. Neil is a practice and finance manager at the solicitor firm MK Law. And before that, he worked for 15 years at a Chambers. So he has the benefit of seeing both perspectives. Our third speaker will be Mike Harris, who will be speaking on Crown Court defence billings from the clerking perspective. Mike works for Chambers People, which is a specialist consultancy providing a range of support services to barristers and law firms. Mike is a former senior clerk, and he provides fees clerking services and training on fees procedures. Our next speaker will be Elizabeth Cooper, from the speaking on the Crown Court defence billing from the legal aid agency's perspective. Liz is a senior caseworker in Crown Court billing at the legal aid agency. And then finally, our next speaker will be Samira Naji, who will introduce us to the legal aid agency's new training website. Samira is business improvement manager at the LAA. And 2 people behind the scenes who you can't see are my colleagues Kyra and Christina from the training and events team at the Bar Council. They are in the background pressing the buttons and making the technology work. In terms of how the evening will go, we'll have each of our speakers giving a presentation. While they're doing that, if after one of their presentations you have a question, the thing to do is to type it into the Q&A box. Please ignore the chat box because we won't be monitoring that. It's the Q&A box that you need to click on, type in your question, and then when all of the speakers have spoken, then I'll open up that Q&A box. I'll read out the questions and any of our speakers will jump in with their answers. What would help me as well in the Q&A box is last year when we had this seminar, someone had typed in the Q&A box, it was a letter C, a number 4 and a letter S. And I was trying to work out what that meant. And someone had to tell me it stands for committal for sentence. So if you are tempted to use lots of acronyms in your Q&As, please don't, and that will help me to read them out. So that's that. I'll just see if there's anything else I should pick up on. Oh yes, you will be, this session is being recorded, and afterwards you'll be emailed a link to the recording. So you don't feel you have to take loads of detailed notes because you will be able to review it afterwards. So I think we go straight in now to invite Tom to tell us about CPS fees.
Thank you very much, Adrian, and I appreciate that some of what I'm talking about may appear to have been slightly outside the remit of why you signed up for this session. But given that most members of the bar both prosecute and defend, and that clerks have to bill both types of work, I hope that it's likely to be helpful in general terms. I have for more than a decade really been one of the main, if not the main point of contact between the Bar Council and the CPS, and was involved in the negotiation for Fee Scheme D and E. Thankfully not Fee Scheme C, which was never popular with the bar at all. Just some headlines really to start with, given that I know that there's a mixture of sort of experience and understanding as far as this is concerned. On any view, although of course we would always have wanted more, Fee Scheme E was a significant improvement, particularly for junior alone cases. The scheme itself brought in a number of structural changes, which it's important that everyone keeps their eye on. My experience personally and the interaction that I have with my clerks is that frequently the cases are underbilled, at least at first sight, until queries are raised with the CPS when they send the initial proposed fee through to be flipped, as it is called. But the main points, when you look at Fee Scheme D and E together, were significant in that day 2 was paid for the first time for some time. Well, that's one way of looking at it. I know that's not how the CPS would have said, because they said it was part of the brief fee. But there were significant changes to when the trial is deemed to start that I will return to. Most significantly, in my view, unused material is paid for on an hourly rate basis once you get past 3 hours. And in any case of substance, that is significant. And I fear that actually the profession are not billing that as they should do, because they think that it will take them time, or in fact, they're not even aware that you no longer have to put in a log for the entire case. Before Fee Scheme E, whenever you were trying to claim any hourly rate work, you always had to produce a log for the entire case, which most people felt in the end was going to take them as long as it would do, or many hours to undertake, and was simply not worth the candle. So that's a significant change, which as the clerks in particular, you need to keep an eye on, because you should have a good awareness in general terms of the nature of the case. And if your barristers are not billing for unused material, then you should be raising it with them. There'll be some cases where there isn't any actually, or very limited amount of it. But many cases, particularly sexual offences, multi-handed cases, it's very difficult to see that prosecution counsel will be doing less than 3 hours work on the unused material. And in particular, counsel should be being sent, in some cases, what's called counsel-only material, which is material which has not been disclosed to the defence, and counsel will have to look at it, and it's being provided to counsel for that purpose. And so you should be billing for that work. The other main changes really that came in as far as Fee Scheme E was concerned was an increase to the range of main hearing and daily fees, and an increase uplifts for all advocates types. So that's multi-handed cases and the extent of the uplift. The benefits to the junior bar in particular should be significant. They may not have seen much of that come through yet because of the impact of COVID, but providing we don't have a third wave, it's very important, in my view, that all these cases are properly billed and to the maximum extent. Can I just give you, from my perspective, and I should make clear that I'm the barrister representative on the Graduated Fee Scheme Appeal Committee for the CPS. So I probably can't answer any Q&As that relate to a specific case if it's likely to be having to be decided by me and my colleagues in due course. But I've got 8 tips that I would really like clerks in particular to focus on, because you'll have some barristers that are brilliant at billing and you'll have others who are not. First of all, you need to make sure as the advocate and as the clerks, you need to make sure that your barristers always endorse the hearing record sheet on the first few days when a case has not properly started. Meaningful progress, that phrase should be used, that's what's required, and meaningful progress can happen outside of court. But if the case is listed for trial, but there's an issue that needs to be dealt with that takes a couple of days, much of it outside court, to get going, get your barrister to endorse the hearing record sheet with what has taken place and use those two words, meaningful progress, because the CPS cannot then complain that, that the trial has not started in accordance with their definition. Second, always question yourself or as the clerk why your barrister has not billed for unused, because and this has a significant impact across the board. One of the reasons for bringing this in was concern about unused material. It's potentially of assistance for those who defend, mainly for there to be a fee structure for the prosecutors as well, as far as that's concerned. But of course, if in due course people are not billing for unused material they have reviewed, then that statistic is going to get taken into account in the future. So it's absolutely critical that you bill for every single moment that you spend on unused material. Third, always double check whether your clerks and whether you as the clerk are billing the right offence. Frequently, I'm surprised that people simply don't know, depending on the page count, that they're far better to be claiming for the more minor offence. A classic example is in a murder case, where if there's also possession of an offensive weapon, the page threshold is far lower, and you may well be better paid claiming for a minor offence for the trial than the murder, for example, with that particular example. Fourth, in multiple defendant cases, make sure that proper thought's been given to whether you are billing the right crack trial or the right guilty plea. Again, probably most people that undertake that work will be savvy to that, but not everyone is. Fifth, tapes and footage. The defendant's interview, 999 calls and evidence in chief are not billable, but body-worn footage is, and that is everywhere in many cases now, and you can bill for it, and people are not billing for it. Similarly, CCTV, very rarely billed for and can be billed, and you only have to provide a log of the work that you have done on that aspect of the case. Sixth, and I feel this keenly as someone who appears in unduly lenient sentence cases, but for the attorney, I'm frequently surprised when I tell the barrister, trial barrister that I'm liaising with when I'm advising the attorney, that they can bill for the ULS advice. They think it's a pain in the neck that they're not going to get paid for. I appreciate the rate may be low, but they will get paid. They have to be paid. The same for rape acquittal advices and terminatory ruling advices. Seventh, any case with a mental health restriction order is a Class A offence, so paid like a murder, no matter what the offence code. Again, frequently not picked up or thought about, and you will find often that the CPS will send the fee on the basis that it's not being classified as a Class A offence, and it should be. And last of all, and eighth, and not to give me any work, don't be shy of appealing or threatening to appeal the decision making. My experience in the past has been that those assessing the fees don't know the fee scheme as well as you may expect. Your own barristers, if you're the clerks, will probably be slightly resistant. They'll be concerned, well, what will the CPS say? You should appeal if you have proper grounds to do so. It does take time, I understand that, but let me just say this. I only see the tip of the iceberg when it comes to the appeals. I know there are many cases in which the CPS agree to pay the proper fee down the line. So make sure that your barristers don't just move on to the next case. Of course, they've got to do that, but make sure that you put in a proper reasoned letter. It doesn't take very long. And in fact, if you know the fee scheme well, you should be able to do it pretty quickly. And I hope that with those 8 tips, you can ensure as the clerk or as the barrister that you maximize the income. Of course, no one and thinks and everyone knows that the payments are still relatively modest, and they are. And were it not for COVID, I was fairly confident that we would have had a fee scheme F by now, but we haven't. But it's surprising how often actually people don't properly understand how to maximize the billing. Every chambers, in my experience, has someone who is very good at it, as well as lots of people that are not. And I would just encourage every chambers to ensure that those who are very good provide internal training as well to their own chambers. And no doubt then a few people will get paid a little more money. Thank you very much. That's all I intend to say at the moment. I'm happy to take any questions in due course. There obviously is a link, as I've said, between the various fee schemes, and as part of fee scheme E, it was very clear that the LAA were heavily involved as well in terms of understanding what was being proposed in relation to the CPS. The job is not the same, prosecuting and defending, but there is obviously sense in there being an element of symmetry to these fee schemes. And as I've said, and I will just repeat this point, all barristers prosecuting must keep a log of the work they've done on unused material. It is absolutely vital, and that now you get paid for it, there is no reason not to do so. Thank you very much.
Thank you very much, Tom. And now we turn to Neil, who's going to give us some tips from the solicitor perspective.
Hello, everyone. As Adrian said, I was a clerk for 15 years, 11 of which of those were spent in a criminal set. I moved to a solicitor's firm about 5 years ago, which has enabled me to have an insight on different operating systems from within both the chambers and a solicitor's firm. I'm going to try and tackle the question of magistrates court billing from the perspective of what I would have liked to have known when I was a clerk, by using the knowledge that I've gained in a solicitor's firm. Firstly, as Adrian and Tom have both said, obviously I'm aware that some people are coming to this with no experience of magistrates court billing, so I'll do a quick background on that. I'll quickly run through the basic structure of magistrates court billing for those who are new to it. The times are reported in units, with each unit consisting of 6 minutes. So 12 minutes is 2 units, an hour is 10 units. Those units are then applied to a set rate for travel, waiting in preparation, attendance and advocacy. These figures then result in a WIP figure, hence the importance of obtaining counsel's times. The fee structure of the magistrates court billing is then separated into different categories, which are summary only, either way, and trial files. Within these 3 categories, there are different bandings, and this is where the importance of times comes from magistrates court billing. The bandings are lower standard, higher standard, and non-standard fees. Non-standard fees, commonly known as Crim 7s because of the form they go on. The WIP figure is therefore used to determine what banding it falls in. So the kind of normal max billing that I've witnessed in these seminars, that's kind of where it normally goes. But from my experience, I think most people are sitting there, most clerks are sitting there saying, well, we do all that. We send our fee notes in, we put our times on, but we're still not paid. So I think the question a lot of clerks, and one I certainly walked away from, was saying, well, how do we get paid by solicitors? When we're sending our fee notes in, why is it so much hard work? And what I've learned from being in both chambers and a solicitor's firm, most systems have the ability to chase fee notes now automatically. They use an email spooler. I certainly know that Lex did when I was using it. So the first thing I would do is to make sure it's set up correctly. And by that, I mean that it's going to the correct person. So not to a general email. So many times I see it going to an info email. It's important to get that fee note to the right person who's going to pay it. I think in this day and age, when we're bombarded by emails, having it go around the house is not the correct way to getting something paid. So the first thing is I'd identify the actual person who is going to pay that fee note and make sure your system is set up to get that fee note to the correct person. I can recall many times people calling up either in chambers or in firm where they're saying, I've chased this, and they've been chasing it and they've been sending it, but to the wrong person. It would be the same scenario, I suppose, if when you're in chambers and you're going to the clerk's at email address, and the fee clerk not being involved in that group, and the fee note not making its way to the fee clerk. It's exactly the same scenario. So make sure it hits the right person. My second point would be to not solely rely on emails, which I think we in this day and age we do too much. Pick up the phone, make telephone contact with the actual person who is going to be the person paying those fees. I think, you know, it's so important to have a relationship and work through the problems. If there are problems on the fee notes and reconciling them, it's easier if there's a relationship and you can pick up the phone, apart from just relying on Lex or whatever Chambers software you're using to just keep email spooling chasers and saying, I'm chasing it by email, but pick up the phone and actually have a relationship with the person and work through if there's any issues, or certainly I think that will make a more efficient way to access it. One other thing that I have noticed that is of importance, I think, and that's one thing I've learned from being in a firm, is the way that we access our cases is very different to the way that a Chambers would access their case. If you was to pull up a Max Court fee note from a Chambers, you'd look straight away, you could look at the date of the hearing, and then you'd access the case via the diary. Having had the joy or misfortune of implementing new software into solicitors' firms and having viewed a lot of them, they don't operate in the same way. You often pull up the case, the case search page is just searching a name, and you'd see the date of offence, the offence, and sadly, a lot of our clients are prolific and prolific on the same offence type. So you could often have use committing many robberies, let's say, and so you pull up their name and you'd have lists of their name, and trying to reconcile a fee note that's come through to an actual case when there's nothing on the fee note that tells me apart from the date is actually quite difficult. If you were to look at a Crown Court fee note that would be sent out, it would often include a T number, an S number, an A number. So the reason that's probably been input into Lex or whatever Chambers software you use is probably because it's going to be used for court serve and to highlight your cases. And then the byproduct of that is that it's going to pull through onto your fee notes, and it goes out on the fee note. It makes it very easy. For a magistrate court case, the best identifier that we could use would be the URN. So I suppose if an easy way for us to reconcile a fee note to then make it easy to be paid to the right case would be the URN would be on it. That's not, I don't really see that often currently. I think that may change going forward with the common platform coming in, because the URN is going to be the primary reference number on there, I believe. So that is what I would encourage. And yeah, that's it really for me.
Thank you very much, Neil. And we now return to Mike Harris to give us a presentation on Crown Court defence billing.
Good evening, everyone. Thank you for coming to the seminar. This week, I'd like to point some items on a number of items. There's COVID-19 concessions, Scheme 12, Common Platform, and Court of Appeal DUNS numbers, which has cropped up this week. If we start with COVID-19 concessions, the first thing to do is to keep an eye on the Legal Aid Bulletin, because within that they are mentioning COVID-19 concessions and when they are going to be withdrawn. Now we're coming up to that point soon. It's likely to be at the end of June, and we're about to get about 3 weeks notice of any changes. Now at the moment you'll probably be aware that the recovery unit run by the LAA has been suspended. Now a lot of criminal practitioners won't know about this item, but if you've got barristers who are mixed practice, then if your legal aid account goes well into the red, then you get a visit from the recovery unit who are looking to reclaim that money. Now at the moment they're suspended. That will be brought back into operation, and if you do get letters from them dealing with accounts which have a red against them, then the thing to do is to take notice of those letters and don't ignore them, because they won't go away and they really do need urgent attention. If we move on to hardship claims, from May 2020, hardship claims are available in cases awaiting trial. They're considered on what's called the least claim possible basis. By that, I mean that the fees that they will pay out will be the fees that they have to pay out under any circumstances. So basically, if your trial goes longer than expected, you will get a larger fee, but you will have your hardship claim taken back as a recoup. Now, provided you've held the brief for a month, you're not going to have a final payment for 3 months, and your claim is worth over $450, then you can make a hardship claim. Pre-COVID-19, there was a fourth element, and that was where you had to provide evidence from the bank manager to say how hard up you were, and quite often bank statements were required as well. Well, element D has been suspended during COVID-19 concessions, but once COVID-19 concessions are over, then element D will be reinstated, and you will have to prove that you have a hardship problem. Points to note: if no trial date's been fixed, then you can claim a final third in the hardship claim. But of course, under Scheme 12, which I'll deal with in a few moments, thirds have been abolished, of course. If you make a hardship claim and you have a determination made, then I'm afraid there are no redeterminations. You're stuck with your original payment. Video link and telephone hearings, as you probably know, they are treated as face-to-face. Travel, your two travel levels, that's 25p for public and 45p for private. At the moment, if you claim 45 pence because you are unable to use public transport due to COVID-19 to socially distance, then you will find that 45 pence is usually paid. Travel can be claimed from your home address, but it's a bit of a two-edged sword, because if your barrister lives closer to the court than chambers, then in fact you might find being paid less than you would if you went from chambers. Deadlines for submissions. Now, the three-month time limit on claims to be submitted is relaxed at the moment. Claims up to 6 months will be accepted, and they will either be without penalty or the penalty will be waived. But cases submitted over 6 months will still have a penalty imposed as before, but it's likely to be reduced. So it's a good time now to get in any old cases and avoid any penalties that will almost certainly be reimposed when this condition is withdrawn. And finally, on COVID-19, soft rejections. The LAA have been trying to avoid rejecting claims and have been putting in their normal 48-hour soft rejection. So do keep an eye on your AGF accounts and pick up on these soft rejections and make sure that they're not missed. Finally, stay up to date. These concessions will be removed as we gradually move out of lockdown. And as I said, we'll probably get about 3 weeks' notice of any changes. Moving on to Scheme 12, as you probably all know, these are for legal aid certificates dated the 17th of September 2020 onwards. There are now 4 schemes in operation, 9, 10, 11, 12. So it's difficult to keep up with the changes. The LEA have published some very helpful guidance notes for each scheme. There's up to 125 pages in each one. But of course, the cost judge will ignore these and will look at the statutory instrument first. The latest statutory instrument is the Criminal Legal Aid Remuneration Amendment Regulations 2020. However, a good tip is to go back, in fact, to the Scheme 9 regulations, which are the Criminal Legal Aid Remuneration Regulations of 2013. And these, in fact, have been helpfully updated by the government. And when you go to this statutory instrument on the web, there are two boxes in the top left, either original or amended. If you go to the amended one and tick on that, the statutory instrument that will come through will have all the changes that are in operation for schemes 9, 10, 11 and 12, and they will set out which of the 4 statutory instruments brought them in. So you will find the original 2013 statutory instrument updated and having all of the changes made and setting out where these changes were made. The Scheme 12 has got a number of changes, as you probably are aware. Cracked trials, the thirds that apply in Scheme 11 have been abolished, and now you get a cracked trial fee wherever it appears between the PTPH and the trial date. You're now not cut into thirds and you get a guilty plea for third one or a second third. Now you get the full fee for all 3. Special preparation under Scheme 11 starts at 10,000 for normal cases, 15,000 for drugs, 30,000 for financial cases. Under Scheme 12, this has been reduced in some cases drastically. For example, for a terrorism offence, it starts at 750, serious violence 700. I could go through them all. They go all the way down to the standard fee, which is a band 17, and that's 150. Now you'll notice that band 1 murder, band 6 finance, and band 9 drugs are missing from the statutory instrument, and therefore they stay at 10,000, 30,000 and 15,000 for your starting point. Unused material already touched upon by our QC. Guilty pleas do not get the unused material fee, cracks and trials only. There are in fact 3 levels. Up to 3 hours, you get an automatic fixed fee, which is based on an hour and a half preparation. Unfortunately, when the statutory instrument was typed, there was a typing error in it, and for juniors only, the figure given was £59 and a penny instead of £59.85, which is arithmetically correct. And therefore, when you put your claims in, you'll find that the LAA will drop it by 10 pence. That is 8 pence plus 2 pence VAT. But this has now been rectified, and if your legal aid certificate is dated after the 20th of February, then in fact you won't lose your 10 pence. Leading juniors and QCs get a higher figure, of course, which is 84.84 and 112.11. You may wonder why the LAA have come upon or gone on 1.5 hours instead of 3. This is because it's an average figure, and it is thought that around about 3 hours work is done overall, and therefore some will have none, some will have more than 3, and the LAA have gone for an hour and a half in the middle. Now, if you have over 3 hours work done, then you can make a claim on an hourly rate, but you must have a log in the style of Appendix F. It used to be Appendix E, it's now Appendix F, and you must produce evidence that the unserved material or the unused material has been produced to you. If you claim between 3 hours and 10 hours, you do not need a log. If you claim over 10 hours, then you will need a log. And the more hours that you claim, then the more evidence the LAA are going to require to make an appropriate award to you. There are in fact a number of items which might be served upon you as unused evidence which don't count, and these are witness statements, documentary or pictorial exhibits, records of interviews, and records of interviews with other defendants. If I move on next to common platform, this has already been touched upon by our previous speaker. There have been claims or complaints over the last few years that the LAA and other agencies have not been joined up because their computer systems weren't compatible or didn't tally. This is now being addressed with a new system called the Common Platform. At the moment, it's rolling out over the country. There are, in fact, 11 Crown Courts which are now part of the system. In the Midlands, they're Derby, Hereford, Shrewsbury, Stafford and Stoke. In London, Kingston upon Thames. In the North East, Newcastle on Tyne. South East, Guildford. Western, Bristol and Taunton. And Wales, Swansea. What does this mean? Well, advocates have to open up an account on the Common Platform, provide a mobile phone number, and they become part of the scheme. What difference does it make to Crown Court billing? At the moment, very little. I think it is likely to make very little change. The paperwork is still put onto CCDCS. You make your claim the same way through to the LAA, but importantly, there is a new item, and that is the EARN number, the URN, and you will see that on CCDCS, this URN number is given out, and you will also notice that on MLC and LEX, the claim forms have been changed so that you can put in the indictment number or the EARN number. Eventually, the EARN number is likely to take over from the indictment number, but at the moment, it's a bit of a grey area. So I billed one for Bristol and Taunton this week, and I have put in both the EARN number and the indictment number. Now, finally, I'd like to just mention something that's occurred or happened to me this week, and that is in relation to Court of Appeal billing. I've submitted some Court of Appeal bills. I put in the supplier account number, and I've had a standard letter back asking for the DUNS number and for the SME status in DUNS. What's a DUNS number? That is a Dun & Bradstreet number that you can apply for. They will give you this number. It'll be a 9-digit number, and the Court of Appeal will want this now when they are making a taxation of your bill. They will also know what your SME status, and that is either small or medium-sized enterprise. On the website, if you go to Dun & Bradstreet, they will tell you all about this, and you will get your chambers certified as a DUNS number, because you're going to find that when you submit a claim to the Court of Appeal, they will want to know what your DUNS number and what your SME status is. They will also probably want your bank name, sort code, account number, etc., which is things that they didn't used to ask for. They just asked for your supplier number, but now they require these details. So provided you've got them at hand, you can send them in to the Court of Appeal, but it must be on headed notepaper to show that it is in fact a bona fide item. Well, that's basically what I'd like to say to you at the moment. Thank you.
Thank you very much, Mike. And I've seen we've got the first question appearing in the Q&A box. For those who've joined late, if you have questions, type them into the Q&A box, and when our speakers have all finished, then we'll address them. So the next speaker is Liz Cooper to talk to us about the LAA perspective.
Thank you very much, Adrian. Okay, so going back to the same sort of themes that Mike was addressing, but with the LAA hat on. So COVID billing and best practice in billing generally. Something we've had problems with, obviously, you'll appreciate, we have access to the Crown Court billing record systems, but not the Magistrates Court. So we've had problems with people billing for attendance at Magistrates Court bail hearings. We have been in the past asking advocates to provide evidence from the court that these hearings have taken place. We no longer ask for this, but what we do ask for instead is an attendance note that sets out clearly the specific Crown Court case or cases to which the hearing relates. So the T numbers, please, for the case, the client's name, the date of the hearing, the name of the advocate, and details of the alleged offence. We ask for this because we do appreciate, as Neil has said, that some defendants are prolific in their activities, and we need to tie up the payment of the hearing to the correct case because it can affect any liability for costs. Okay. Please, if you're billing on a common platform matter, use the URN. If it's not a common platform matter, please, please, please use the exhibit T number, S number, or A number. There are a number of bills we have received recently that refer to the URN, but the case is not in a common platform area. It's not a common platform case. If we have a URN rather than the TS or A number, we cannot find that record. If we can't find that record, you will not be paid. So please, please, please use the exhibit number. We can sometimes search exhibit for the record, but if you've got a common name, slightly misspelt name, or a prolific offender, we have no chance of finding the record. Our bill payment system, unfortunately, has not been amended yet to account for the fact that the Scheme 12 crack trial fee is now the fee for the basic fee for a trial. It was a choice of building the system that would interact with common platform and allow us to make payment for cases being dealt with under the common platform, or update the system to pay for Scheme 12 fees. Understandably, because of the emphasis on joined up government, etc., they went for divert the resources to building the common platform billing systems rather than changing the Scheme 12 payment system on our bill payment system. So our caseworkers are trying to look out for and remember the correct bill, but please, if you see that you've been paid the wrong amount, just come back and say it's a Scheme 12 case. The crack trial fee is the trial fee. We won't be offended. We're doing our best to pick them up and correct them as we see these errors. But if you go back and say, or if you start off by saying it's a Scheme 12 case, please pay us the right fee, we would appreciate that. And something maybe dear to my heart, if you want written reasons, please, please, please use the request written reasons functionality on CCCD. Don't just say it's as part of your request for redetermination, and if you don't pay me, I want written reasons. It goes to the wrong work queue, it's allocated to the wrong people, and you won't get written reasons. So if you want written reasons, please use the work queue appropriately. We do want to pay you what you're entitled to be paid. So if you're, Scheme 12, please actually pay, claim your unused material. For the up to 3 hours, you literally just need to say unused material 3 hours, and we'll pay you. If you want up to 10 hours worth, you need to fill in and submit form AU1. It's minimal, seriously minimal form, and just proof that you had X many pages of unused material. Anything over 10 hours, then we do need a work log and a copy of the material viewed or claimed for. You know, please also claim all the hearings that have taken place. We still have advocates who are claiming for cases and missing off the standard appearances that would normally have been part of the basic fee in Scheme 9. Scheme 10, 11, 12, etc. Every hearing has a fee, so please claim them. In terms of the common platform system itself, we don't have direct access to view it in the same way as we do exhibit. Rather, the system is built, it feeds data to us. We then convert it into data we can read. There are a few kinks in terms of systems talking to each other, but at the moment, the common platform system is evolving. HMCTS will build a bit. They will then come to us and say, right, we built this bit, please test how it interacts with your system. We then test that and build that. So it will gradually take, you know, and develop over time. So if we come back to you at the moment and say, can't find the information, we need to check with HMCTS, it will take a few days. That's because the systems aren't talking to each other properly at the moment. And that is being worked on, but things are taking a little bit of time in that respect. Some cases will move from a common platform to exhibit. If that happens, please bill it under the exhibit number, but also tell us the common platform URN number, as if it was a case that had transferred from one Crown Court to another. You would give us both T numbers. In the same way, if it's moved from common platform to exhibit, please give us both numbers. We have a better chance of finding the records and paying you properly if we can find and validate the hearings. And that's it from me.
Thank you very much, Liz. And now over to Samira, who's going to introduce us to the LAA's new training website.
Thanks, Adrian. Like Adrian says, I'm going to talk to you about the LAA provider training website, legal aid learning at justice.gov.uk. And in particular, the crime content, which was added in April this year, and which is a new feature of the website. So the old CCMS training website for civil providers needed to be changed and developed. And before we did this, we went out to providers to gather information on what changes they wanted to see, and if crime providers felt that a training website would be useful to them. Providers fed back overwhelmingly that yes, they did want a crime section on the training website, and that they wanted the guidance to be improved and in one place. We then went out to the internal teams, the customer service team, to gather data on areas which generated high call volumes. We went to the crime teams and gathered data on areas which generated high reject rates and appeals. And we took this data and designed the content which sits on the crime section of the website. In the last 7 days, the crime page has had 377 hits, and to date, it's had 734 hits. The most popular sections are the crime billing section with 363 hits to date, and the application section with 121 hits. So if it's okay with you, I'll just share my screen to show you what the website looks like. Okay, so I hope you can all see that. This is the home page of the website, and like I said, you can find it at legal aid learning at justice.gov.uk. So this home page has some information on the content. You'll see this feature here, it's unavailable at the moment, but it's live web chat. This is also a new feature for crime providers, as previously it was only available to civil providers. But it's just a live online chat function for providers to be able to contact the LAA to raise any queries. Crime providers are slowly starting to use this. I think it's because they didn't know about it. Civil providers had this service available to them previously, so the uptake for civil providers is really high. But crime uptake is a bit slower. So I'm hoping that that will increase as the website becomes more popular. Also, we have a coming soon section, which talks about what we want to do going forward with the website. And the sections here, the squares here, are where you'll find the guidance that I'm referring to and which my co-speakers have touched on briefly. So if we click on the crime section, it will take you to this page. This is in the development stage. This isn't what it will look like permanently. We're hoping that this will improve. But if you click on this and go to course, it will take you to the different sections within the crime team. So if we look at crime billing, for example, which a few speakers have already spoke about, and the fee scheme changes, we've got the different sections. So we've got the litigator training guide, advocate training guide, hardship claims document, the criminal legal aid reforms for advocates, which people have spoken about, unused material and what you can claim and how you should claim it. There's also links to the different forms that other speakers have referred to. The criminal legal aid reforms for litigators, appeals, written reasons, cost judge appeal documents, travel and disbursements, litigator travel and disbursements, and prosecution pages of evidence and electronic pages of evidence. So if I just take you to the advocate training guide, and I've picked this one to show you how it's different to the Crown Court fee guidance, which already exists on .gov. We took the feedback that providers gave us, which is that they wanted a sort of more concise version of the guidance and for it to be in one place. So that's exactly what we've done. So we've just put the different fee schemes in one place, and we've got a section on miscellaneous fees and just other scenarios that you can claim for, uplifts more than one fee, for example. And if we look at the first section here, this is where all the links are to the more substantial guidance. So all the Crown Court fee guidance, if you click this link, it will take you directly to the .gov page, fee scheme calculator, local bar allowance for travel, and CCD and how to set up CCD users. And then if we go to the actual guidance itself, so this is just an example, fee scheme 9, representation orders dated the 5th of May 15 onwards, and that the fact that the first 4 SAFs are included in the basic fee, the PPE threshold 10,000 applies, and the first 2 days of trial are included. And then the difference between the different fee schemes. So representation order 31st of December 18, we go to offence bands. Each standard appearance fee attracts a fee, and each trial day attracts a fee. And then scheme 12 and the difference there, the different criteria there. We've put some information around fixed fees and the different numbering for fixed fees, because we found that quite often they were submitted with the wrong number. Different case types and so on. Discontinuances, what the criteria is for that, guilty pleas, and so on. And this is how it sort of looks if you access it. Newton hearing, some information on there. If I can just come out of this. I can't get out of this because of the... Okay. It's not letting me go back. Sorry. I think, has it stopped sharing?
Yes, it stopped sharing.
Okay, I don't know why it's done that. I think I've lost the screen, sorry. Just bear with me a second, I'll just try and get it back. Okay, I can't get it back, but I can see it here, but for some reason it's not sharing. I don't know why it stopped sharing. Okay, let me just see if that works. Can you see that again?
Yes, back on.
Okay, great. So just take you back to the home page, and another feature of the website is recorded webinars, and this is an area we're looking to develop and add to. So any sort of complex areas of billing or complex areas of crime, we want to have webinars on. And the feedback that we've had is that you want those to be presented in short, quick presentations, which you can just watch and understand how it is that you can claim what it is you want to claim. So maybe a good idea for this would be a section on unused material, as that's something that's new and that we think that billing clerks could maybe benefit from. The online support tab is for anything that you have, any technical issues that you have with any of our systems. You would just click this tab and you would get help and assistance on that technical issue that you're having. Trainer-led online modules. This is something that you can sign up for. So any providers can sign up for trainer-led online modules. And this is for more in-depth training on a particular subject. So going forward, what we want to do is we've taken an agile approach to this website and building the website. And what we're going to do is continually get feedback from providers and users. We're currently holding some user research sessions with providers and solicitors to ask what they like about the website, what they don't like about it. So the crime page that I showed you before, the unnecessary 2 steps, we've had a response to say that they feel that we could bypass that, that would be better. So we're going to improve that. We've taken some feedback on recorded webinars, and we've got notes, and the training team are going to develop some training modules based on that. And also content. So any content that providers feel we need more information on, we're going to develop that and add that. And that's all that there is from me.
Thank you very much, Samira. We've had one question that's come in relating to that, because you've said that this is developing and things are to be added. But the question is, has what we've seen gone live?
It has, yes. It's been live since April. So like I said, in the last 7 days, it's had 377 hits. So it's gaining popularity as more people know about it. The feedback that we've had is that more established billing clerks probably wouldn't use it, but those established billing clerks have said that it would definitely be used by more junior staff or staff that are new to billing.
Thank you. So turning to the next question, and to those who've got more questions, please type them into the Q&A box, because there's still time for you to ask your question, and we'll come to them when you type it in. This question, well, I mean, it might be for Tom, Mike, and Liz. It says unused material claims, what material is allowed? And I mean, I don't know if there's a difference between CPS and defence fee schemes in terms of unused material and what counts as material. Maybe Tom, do you want to start off by saying something from the CPS side, and then we can pick up with Mike or Liz?
Yeah, thanks, Adrian. I mean, there's a symmetry at the bottom of the 2 fee schemes in terms of the fact that there's 3 hours is assumed, it's paid as 1.5 in a similar way, but above that, the CPS position is, as I understand it at least, probably slightly more open, and certainly at the further reaches of it, there's no distinction. And what I really mean by that is it is reasonable time spent considering unused material. If you are prosecuting the case, and I haven't had any fee appeals yet, it seems to me very difficult to see how you are not entitled to be paid for reading every blade of the unused material, because you are prosecuting the case. There may be a distinction in a multi-handed case as to what the defendants need to look at. But prosecuting, that unused material will not only be that which has been disclosed to the defence, and of course it's been disclosed because it is reasonably capable of assisting the defence or undermining the prosecution case. So how prosecution counsel can't be expected to read that with care is beyond me. But there may be other material that the prosecutor counsel has that is not disclosed to the defence. So that's why I suggest it's slightly more open than it may be for the defence. And I can't see any circumstances in which a CPS lawyer could say to prosecution counsel, you don't need to read that unused material, even though I've disclosed it to the defence. The position might be slightly different if there were two advocates for the prosecution, but in general terms, it really covers all unused material as far as the prosecution are concerned.
Mike or Liz, do you want to say about the defence side?
Well, if I start off, unused evidence, I would guess by and large will be a lot of telephone evidence, but they've specifically excluded witness statements, documentary or pictorial exhibits, records of interviews with assisted person, and records of interview with other defendants. Now, I would also guess that the vast proportion of that evidence will be served, but if some of it is not used, it's classed as unused material, then it will be excluded. The LAA, as I understand it, will treat this very similar to special preparation. It's in the gift of the LAA, and it is for you to prove that A, you had the unserved evidence served upon you, the unused evidence served upon you, and that you had the number of hours that you did, and that they were all done, and that the LAA should be entitled to pay it to you. The more you claim, obviously, the more information you're going to have to give to the LAA to get your hours paid.
Yes, it's the disclosed unused material that is paid. The reason for the exhibits, etc., is that those are the things that are defined in the regulation as served, pages of prosecution evidence. So that's been withdrawn from the definition of unused. But anything that is disclosed as unused, it is reasonable time spent viewing that material. It can be written material, it can be CCTV, it can be anything that is provided as unused material that can be claimed for.
Thank you. The next question is, do any of the speakers have a recommendation for what would be the best software to use when to calculate the claim as a sole practitioner claiming defence fees? Now, I mean, Mike may want to answer because he has a lot of experience going around different chambers, but I also know that I think that the LAA's website has sort of some calculators on it as well. But Mike, do you want to start off as to whether or not a sole practitioner could use some of the software products that are out there?
Yes, I've got a number of sole practitioners who have got, in fact, one particular has no computer at all. So you don't actually need a computer to do it. What I would recommend would be the LAA calculators, which are accurate and good. Once you've got your claim, if you like, from the sole practitioner's point of view, you would then have to go over to AGFS and manually enter that claim, and provided your manual claim matched what you had worked out on the LAA calculator, then you should be able to submit your claim correctly. And of course, you would then add in the information that you get from CCDCS, such as your legal aid details and your indictment, and anything else that you would need to prove, such as an armed element or an aggravated element for arson, for example. So I would definitely recommend that the LAA calculators are the best things to use. There are others on the market, but certainly the LAA is a free service, and I would recommend using that.
Thanks. And would Liz or Samira like to say how a sole practitioner could find the right page on the LAA's website that has that calculator?
Yeah, the training website. So if you go to the advocate fee guidance section on legal aid learning at justice.gov.uk and click on crime, if you click on advocate fee or litigator fee, whichever one, there's a link at the beginning which will take you to the fee scheme calculators, and that link is on the litigator and advocate fee page. I was just going to ask.
Sorry, it's a tick box system, and literally you tick the boxes that you need to fill in, and it will automatically populate the fee lines with telling you exactly what you're going to get, and they're very accurate.
I was just going to ask Adrian, would it be helpful if I posted the link to the website? I've put it in the chat section and I've answered a couple of Q&As, but is there anywhere else?
Yes, if you put it in that chat section, then people can access it there. Thank you. The next question is, with the change in credit guidelines, a significant number of very serious cases with long sentences and complicated ancillary orders are being committed for sentence. This attracts a flat fee of £152. Is there any way to claim an uplift for the extra work?
Adrian, I'll take that if I may. Yes, indeed. If you don't think that the flat fee is sufficient or appropriate to the work, then you can claim an ex post facto fee from the criminal cases unit, rather than claiming the flat fee.
Thank you. Any other thing to add on that?
Yeah, the only other thing I'd add on that is that quite often when you have a committal for sentence, and it's becoming more frequent now, Newton hearings will be heard. You cannot claim a Newton hearing under the scheme at the moment. Well, what you would do would be to ask the LAA to reconsider the £152 and say that this turned into a Newton hearing. Here is the work that I did. Can you treat this in effect as an ex post facto claim, please?
Yeah, and can I answer that from a prosecution perspective as well in relation to fee scheme E? I mean, in a way, the question belies one difficulty that there is in terms of justifying stepping out from the fee structure, because the question proceeds on the basis that it's more normal that this happens, and that is right. And the recent case of Placu very much is requiring defendants to indicate their guilty plea in the magistrate's court. But you need exceptional circumstances to step outside the fixed fee prosecuting, and that is not going to be straightforward. I'm not suggesting that you won't be able to do it in an appropriate case, and the manual of guidance expressly also says that a Newton hearing in that type of case will not be paid as a Newton hearing. So there's a difference between the prosecution and the defence fees, and if it becomes more frequent, it's no doubt something that will have to be taken up with the CPS.
Thank you. The next question is, under Scheme 12, if the defendant enters a not guilty pleas at the plea trial and preparation hearing, and then the prosecution offer a no evidence on the same day, does that constitute a cracked trial?
No.
No.
Simple answer.
To be honest, it has to be on a later date. Same day, it wouldn't count, in my view.
Thank you. The next question, I'm not sure I understand it, but I'm sure that you will, is, are notes for taxation useful?
In my view, very much so. We don't want to flood the LAA with notes for taxation, but we have to prove our case. If anything unusual happened, and therefore the LAA weren't there at court. They don't know what happened, and therefore if we can put into a short taxation note what happened, then it will assist your claim and hopefully assist the LAA. I wouldn't recommend doing this in every case, because the vast proportion of cases will go through normally. Therefore, I think it should only be used sparingly when you've got a point that you want to put across.
Very much so.
Thank you. We've got no more questions yet. Let's just hold on for another minute in case someone's typing away. Because we're still officially got till 7:30, so there's time for a couple more questions at least if people have still got questions. So we'll just give it another minute in case anyone's wants to type something in. Actually, while we're giving it that minute, oh, hang on, there's one just popped up. Okay, so the next question, if the defendant sacks his legal representatives on day one of trial before the jury is impaneled and then represents himself, can counsel claim a cracked trial fee? If not, how can he or she claim for their preparation?
Yes, they should be able to claim for a cracked trial fee in those circumstances.
Yes, I'd agree with that. If the defendant went on to represent himself, then the main trial fee, or the main hearing fee, as it's called, I would say, would be a cracked trial.
Thank you. And I'll just give some roundup closing remarks whilst we still see if there's any more that come in. Here we go. Right, if a case goes to a second trial and a new indictment is filed adding a new defendant, would this be paid as a trial with no reductions instead of given a percentage reduction?
If it's a totally new indictment, then yes. If it is an amended indictment adding a new defendant, but it's actually not a new indictment preferred, then no. So it would depend exactly what happened.
Thank you. And the next question is, what evidence is required to reach a higher band, e.g. a fraud over £100,000?
Ideally, sorry, Mike.
No, I'll let you carry on.
I would say ideally, statement from prosecution counsel or the police or fraud investigators telling us how, the case became valued at over 100,000. Just saying, oh, well, it was 100,000 doesn't help us. We need, sort of as unbiased as possible, how that 100,000 figure was arrived at.
The way I approach it is that I go to CCDCS, I go to the case summary that's on there, and quite often that will have in there the value of the fraud or whatever, or theft, whatever has been undertaken. And if that's not sufficiently detailed, then quite often you'll have witness statements which will set out exactly what the value of the property stolen or the fraud perpetrated. And therefore, if you send those to the LAA with your claim, that usually is sufficient. But you have to remember that the statutory instrument actually says that it is for the advocate to prove his case and to prove to the LAA that what you're claiming is sustainable. And if you just say, well, it was over 100,000, they're not going to know that. And therefore, it is for you as the advocate or the billing clerk for the advocate to prove your case to the LEA's satisfaction.
Yeah, and Adrian, it's very similar prosecuting. You would provide the indictment if it's specified there. It sometimes is specified what the loss is, or extracts from statements or exhibits.
Thank you very much. I think that's probably exhausted our questions now. Closing remarks so that those who've joined this seminar will be emailed a feedback survey form. So please feel free to fill that in so we can learn for the future. The next legal aid billing seminar is going to be on family on the 9th of June. And so feel free to sign up for that one as well. You go on the Bar Council's website, and then if you click on the Training and Events tab, there's a calendar which has all of our events and you can sign up from there. And finally, just to thank very much, as well as those who've joined, of course, to our speakers, very much for your expertise and giving your time to help us all. And the Bar Council's grateful that none of you have submitted a bill to the Bar Council for your time this evening. So I now wait for my colleagues in training events to press the button to terminate our seminar. Thank you very much.